It's time for some trailblazing justice. Special guest and OGRC Senior Counsel Steve Wax is back for another episode of our special series, Waxing Confidential. In this episode, we dive into the tension between democracy and executive overreach. Steve and Bobbin unpack the significance of a recent landmark court order pushing back against Trump's assault on law firms. They draw unsettling parallels between what we are currently seeing at the national level and pre-Nazi Germany, and provide an overview of due process and habeas corpus. Join us as we explore the enduring importance of the rule of law and civil liberties and its connection to democracy. It's all coming up on Trailblazing Justice. This is Trailblazing Justice, episode 61, recorded Wednesday, May 7th, 2025. Waxing Confidential, part 2, Then They Came for Me. It's time for Trailblazing Justice, the weekly podcast where we discuss civil and criminal rights in Oregon and beyond. Trailblazing Justice is a production of the Oregon Justice Resource Center. And now, here's Bobbin.
Welcome to another episode of Trailblazing Justice. My name is Bobbin Singh. I'm the Executive Director of the Oregon Justice Resource Center. And this week, we're back with Steve Wax in Waxing Confidential Part 2. Today, we're going to talk about parallels that Steve is seeing in the history of Germany, due process, and habeas corpus. But first, we're just going to do a little recap of our last conversation where Steve discussed the attack on the rule of law. You can find that episode in the podcast in the library of our podcast or on any major podcast provider. But Steve, since we've had that conversation, there's been an update. We discussed the attacks on law firms in which Trump issued an executive order targeting law firms. And talking about those law firms that capitulated, but there are a couple of law firms that decided to fight back. And one of them is Perkins Coie, which has a presence here in Oregon. But there was an order issued last week. You want to talk a little bit about that? Give us an update of what's going on?
Sure. Judge Howell, District of Columbia District Judge, issued an order in the case brought by Perkins Coie that was quite interesting to read, quite powerful. And I was really struck by the way in which she crafted the order and/or the lawyers who presented it to her from Perkins had urged her to craft it. Unlike some of the other orders that have been issued in some of the other cases seeking either temporary restraining orders or rehirings, that left some wiggle room for the government, or that were coming before the courts in a posture such that an appellate court or the Supreme Court in a couple of instances could issue administrative stays of the orders. Judge Howell issued a final order, a permanent injunction, and was very specific in telling specific government officials what they personally needed to do. Now, she directs the defendants generally from taking any of the actions that would interfere with Perkins and Perkins' relations with its clients, directed to rescind all formal or informal guidance or other direction provided to officers, staff, employees. So she's not leaving any wiggle room. Well, the government could say, we didn't put this in writing or we didn't put that in writing. She's anticipating in this order, I don't care what form this was in, written, formal, or otherwise, you're going to rescind it. But she went beyond that and directed the defendants, all the named officials in the lawsuit, to notify all officers, staff, employees, and independent contractors subject to the order that it is unlawful, null, and void in its entirety. And they are to disregard the order and all prior formal or informal advice, opinions, directions, etc. And she went beyond that as well. They have to stop any security clearance review. They have to restore, clearances. And then she gets to the Office of Management and Budget and Russell Vaught, the director, by name, is directed to identify all government goods, property, services, et cetera, that had been identified in the executive order, and immediately issue direction to the relevant heads of all agencies that they are to reverse and rescind any cessation of the provision of materials that was stopped pursuant to the order, and to communicate that to, again, all other people in the government involved. Then she goes to Pamela Bondi, the Attorney General, and to the Andrea Lucas in her official capacity as acting chair of the Equal Employment Opportunity Commission, directed to immediately cease any investigation of Perkins Coie made pursuant to the executive order, and to provide notice again to other people, and then specifically to Bondi and Vaught, two cabinet members. They have to provide copies of the order to any and all defendants and departments and agencies and entities, and direct the recipients to comply with the order under penalty of contempt. So, personally setting up the responsibility of several of the top government officials, including two cabinet members, to undo what they did and to notify everyone else in the government of their obligations. And if you don't, you need to understand that I'm prepared to hold you in contempt. Now, the initial response, I read one thing that the Attorney General said, which was incredibly disparaging of this order and saying how wrong it is. But she told, some of her minions, this is the order, here it is, you got to comply with it. If they don't comply, if the government officials do what they have been doing in so many of the other lawsuits of paying lip service to it or ignoring it completely, this order sets up the direct confrontation between the judiciary and the executive, with the judiciary saying, we've got the power. I'm telling you what to do. You need to obey my order. And if you don't, I'll hold you in contempt. Now, to date, I have not seen any news that says that there is a contempt proceeding that has begun. But this is the type of order that I would hope all of the federal judges who are hearing all of the cases against the Trump administration issue. Because if you issue something that's subject to interpretation, well, they won't comply. If you issue something that's a bit gray, they're not going to comply. And then enforcing it is incredibly difficult. This may be incredibly difficult to enforce this order if they don't comply with it, because then who has the gun?
Yeah.
U.S. Marshal obeying the judge's order or obeying the Attorney General's direction. But in terms of the law and the way the legal process should work, this is a model of clarity and strength. I just loved it when I read it.
Yeah, and we talked a little bit. We talked about sort of that tension and that potential conflict in the previous conversation that we had. But what I want to point out too is, ask you your thoughts on the contrast right now that exists between the law firms that decided to fight versus the ones that capitulated. And the judge in this order, and what people are referring to as footnote 3, it's this long footnote, but it concludes with, if the founding history of this country is any guide, those who stood up in court to vindicate constitutional rights and by so doing serve to promote the rule of law will be the models lauded when this period of American history is written. I mean, the footnote, the entire footnote is amazing, but to end with that, I mean, it really is calling out those law firms that decided to capitulate and give up all the type of services that they're planning to give to the Trump administration. I mean, how stark is that for you? I mean, just seeing a footnote like that from a federal judge, really basically calling out those firms that, succumbed to the attack on the rule of law and basically abdicated their responsibilities as, attorneys.
I was so pleased to see it. It is so important for everyone in the country to read and to understand what she's talking about. People forget that one of the first presidents of the United States, John Adams, one of the founders of this country, earlier on in his career, he represented British soldiers under the British law, under the rule of law, who had taken action against some of the patriots in, I think it was 1773, before the Declaration of Independence had been declared. A lawyer has to uphold the rule of law. You give in to a bully, you give in to a dictator, whether it is the law firms capitulating to Donald Trump or whether it is Neville Chamberlain capitulating to Hitler over taking over the Sudetenland in Czechoslovakia, the result's the same. A bully, a dictator, is not going to stop if people don't stand up to him and tell him forcefully, you are wrong. I was upset, angered, when I read initially Paul Weiss and then the other law firms that capitulated to Trump. I thought it was outrageous. Mm-hmm. And I read one of the justifications. Well, it's in their business interest. Oh, yeah, fine. It's in the interest of our existing clients. Well, that's true. But you have a higher obligation as a lawyer to the rule of law itself. And there have been a fair number of legal scholars who've written on that subject. And I am so grateful that several of the federal judges in commentary to lawyers who've been appearing in front of them and in opinions are making this incredibly strong statement about the importance of our profession to the rule of law. And, the Oregon Bar Bulletin printed what they call, a parting shot from me, the last page of the May Oregon Bar Bulletin, in which I wrote it before any of the firms had capitulated, and it was revised slightly at the end of April after the litigation had progressed a little bit further. But I said to all the lawyers of Oregon, we need to stick together. Mm-hmm. And there is strength in numbers. There's always strength in numbers in this type of fight. One gives in, then they start picking off the others one by one. You stand together, and then what is Trump and the administration going to do? If all the lawyers, all the law firms say, no, that's not what we can do. Those firms that capitulated, in addition to the outrage of giving him the authority to control approximately $1 billion in pro bono hours, what an outrage.
Yeah.
But they also are saying to the profession and to the lawyer purchasing public, well, we're okay. Hire us because we make nice with them. You never make nice. You can't make nice.
Yeah, I mean, one of the hopes I do hope for. One of the things. I just wonder if there'll be an economic consequence to them in the long run for surrendering as to the type of. I think it was Apple that already pulled out from one of the law firms, but I do wonder if this will have a negative impact in the long run. Now seeing the contrast of a law firm that stood up and, has won so far.
Only time will tell, Bobbin, because the reality of our country is that there were enough people who voted for Trump to be president. There were enough businesses that are supporting his efforts to provide more tax breaks to the super wealthy, who are likely to or may, shift their allegiance from Perkins, to Paul Weiss.
True.
So time will tell, which side, that shakes out on. But as the judge said, when the history is written, hopefully it will be written as she described it. Of course, the reality is the victors always get to write the history, and we don't yet know who the victors in this fight are going to be.
Yeah. Well, if you want to hear more or about the attack on rule of law, you can listen to one of our the previous episode that we had with Steve. I want to segue into the next theme or article that you have coming out. It will be published concurrently with this episode, but it's titled "First They Came For," and this title is inspired by a well-known confessional that I think we're hearing more and more and more these days. Because of the reality in which we exist and the encroachments on our rights and liberties that are occurring. But I figured it'd be kind of nice to start off reading that confessional. Would you? And the individual that wrote it, I think everyone is now familiar with this confessional, is Pastor Niemöller. Hopefully I'm pronouncing it right. But Steve, do you want to start off as we segue into this next conversation, just reading the confessional to help set the tone for what it is that we're going to be talking about?
Sure. Very brief background. Pastor Niemöller was an early supporter in Germany of Hitler and the Nazis. He became disillusioned relatively quickly. And in 1935 and 36, he started speaking out against some of the abuses of Hitler and the Nazi Party, if you can call it that. He became sufficiently outspoken that he was arrested and imprisoned in 1937, and he stayed in prison until the war ended. A year or so after he got out of prison, he was reflecting on his early acquiescence to what Hitler was doing and to his silence and the complicity of silence. He gave a talk. He didn't write this down, but what he said has been, written down, and a version of it appears at the Holocaust Museum. And it goes like this. First, they came for the communists, and I did not speak out because I was not a communist. Then they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. And then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak out for me. Some people have rewritten that with other entities and individuals for our time. Can start it with first they came for the migrants. Mm-hmm. I didn't speak out because I wasn't an immigrant. Then they came for the trans people, and I didn't speak out because I'm not trans. Then they came for the gays. I didn't speak out because I'm not gay. Then they came for the Jews. I didn't speak out because I'm not a Jew. Then they came for the blacks. I didn't speak out because I'm not a black. And then they came for me. And no one was left to speak out on my behalf. And substitute whatever other groups, seem appropriate to you. But I thought that this is a very compelling reminder to all of us about the need to dissent, to resist, to speak out, and to do so early, even if it doesn't feel that one is being personally attacked. Because the history of our world suggests to us that we are not immune to the ever expanding power and abuse of power, going from the highly disfavored to the slightly less highly disfavored, and ultimately to whatever group the dictator in power wants to go after.
I mean, I've been having more and more conversations around this, both things to help encourage sort of the civil rights people that I know in civil rights advocacy, but I also see it on the other side, which is, for at least a civil rights advocate, I encourage people to practice advocacy, practice standing up for people, practice, because it doesn't matter how small it is. But you have to practice advocacy. You have to practice, pushing back against systems and bullies. Because if you're not practiced in it, like in small ways, it's very hard in these very big moments then to be activated, to actually do something, because you're not practiced. You haven't exercised that muscle. Conversely, when you read something like this confessional, what it really highlights is this sort of fascist side, this side that's taking away rights, is essentially what they're doing. They're practicing the oppression or suppression of individual or communities. They start with one, get people familiar with it. They continue that practice, get better, more refined. They understand the tactics, the propaganda, and then they expand it out, and they continue to expand it out, and they become practiced at this. And it's us having to push back against their ability to become too good at this. And that's sort of what it reminds me of when I hear it. But you had some personal anecdotes in your essay that you referred to. I don't know if you want to share them or not, but as to like why this means so much to you at this moment, or why this is such a compelling confessional, or these words are touching you in so many ways right now, or meaning in like a very profound way.
Sure. So Passover Seder in April, we hosted it at our house. It's one of the few rituals of any religion that I really enjoy. And I enjoy it because the version of the Haggadah, or the Passover story book that we use, is it's political and talks about the importance of fighting against tyranny and peace and justice and equality for all peoples in all times. Well, I heard myself saying, at the Seder, we don't not just read through the book. We have discussions that go, back and forth. And I said, things are bad, but I don't feel personally threatened now. Yeah, I understand that and believe that what Trump is doing with using anti-Semitism as a way to try to get control over law firms and universities is of itself a highly anti-Semitic act, because he is using the Jews for his own purposes to aggrandize his own power. And I don't believe that he really cares, about anti-Semitism, that there is this very other ulterior motive. But I said it. And one of our very dear friends, couple, we've been friends with for nearly 40 years, have a child who has transitioned and had gotten married recently to another person who had also, transitioned. And they heard what I said and responded to it and said how afraid they were that for them, what's happening is already personal, and how they are making plans. Whether or not they're prepared to carry them out is a different story. Whether or not the plans are naive, again, a different issue. But they're making plans to leave the U.S. for a country that they believe, at least now believe, would be more open to two people who have transitioned gender and have gotten married. I heard them, and I heard their fear, but I also heard what I had said, which caused me to reflect on this, prose poem by Niemöller. Doesn't matter, that I wasn't feeling personally affected by or endangered by the policies of the Trump administration. I am endangered by them because if the least popular, among our people is being threatened, I'm being threatened. We're all being threatened. It goes back to Martin Luther King's saying, which I think is above the courthouse jail in downtown Portland. Injustice for one is injustice for all. Mm-hmm. And I that was a bit of a wake up call for me, to hear them, and I wrote about it, and I would encourage everyone to reflect on how they're feeling. Now, I'm going to come back to that theme in another essay that I've written, which is still in progress, but is likely to be posted sometime in the next few weeks, which is how we are all affected by what the Trump administration is doing, not only with respect to immigrants, trans people, getting kicked out of the military now. Supreme Court, allowed that to go forward 6-3 this week, even though both the lower trial court judge and the appellate court had struck down, the order. But the Supreme said, no, we'll let the order go into effect, while it's being litigated, which for those people who are affected means, they lose. They get kicked out. Their careers are over. 2 years from now, when the lawsuit is over, if they happen to prevail, how do they get that time back? That was a bit of an aside, but it's part of what's going on here. We're all being affected.
Yeah, I mean, this is the constant danger that we're under at this point is every day, any day, it could be who's next, what population is next, what sort of marginalized, or as you had mentioned, the least popular sort of populations or segments of our society are going to be targeted next. And it happens not only slowly, but it happens quickly. It's a weird thing because it ends up, as the confessional talks about, like all these things are happening and you don't think that you're being impacted by it, but then all of a sudden you are. And, it is, it's an interesting phenomenon. And I think this is partly why I'm interested in hearing your thoughts on, what you saw in the history of Germany and the Weimar Republic and the lead up. And I think it's so, nice that we started with Pastor Niemöller's confessional to help set the kind of the tone for the conversation, and that we're going to look at that history. So you had mentioned you wanted to talk about that. What is it about? I know people always you hear it in commentary. This is like pre-Hitler Germany, or how it became, or how Hitler came to power, and how, it was through democracy and the use of laws and et cetera, et cetera. But I don't know if people really know what that means. So you care to share some of that history with us?
Absolutely. So, Bobbin, I don't know. I've been quite fortunate in my career to have been, in the wrong place at the wrong time, or the right place, at the right time, and have had a number of very interesting opportunities. One was back in 2012. When the German Federal Bar Association had put together a program on the law in Nazi Germany. And the Oregon State Bar, which has done a fair number of wonderfully progressive things even though it is constrained with respect to politics by an Oregon Supreme Court decision. They were a co-sponsor of a program that was put on in the federal court. And I was asked to talk about the rule of law, and the title of the talk that I gave, the theme was lawyers, tyranny, and the rule of law. And I used one of my favorite quotes, from Shakespeare. First thing we do, let's kill all the lawyers. And those who don't know, I think we went over this last time, Shakespeare's really saying lawyers are critical to being there to protect democracy from despots.
Also, interestingly, in the judge's order that you talked about earlier, it's in the first paragraph of the order citing that quote.
Yeah.
Anyways, just a call back to that. Yeah,
absolutely. So I have to give this talk. So I did some research, and I love. One of the things I love about the law, and have been so fortunate in my practice of the law, is you get involved in so many fascinating things, some of which have nothing to do with the law. You represent guys who are, accused of a tax fraud involving cattle. And I learned how to convert a spring heifer to a fall heifer. I didn't even know what a heifer was, but, you get into stuff. So I studied Nazi Germany. And I learned that Article 48 of the Weimar Republic Constitution, the Weimar Republic being the government that was set up for Germany, in Germany, by Germany after World War I, had a provision in it that said, in case public safety is seriously threatened or disturbed, the Reich president may take the measures necessary to reestablish law and order, if necessary, using the armed force. In pursuit of this aim, he may suspend the civil rights described in, and then a host of articles of the Weimar Constitution, which would be familiar to anyone who is familiar with the United States Bill of Rights, having to do with due process and equal protection and free speech and association, et cetera, et cetera, et cetera. And scholars who wrote about the what happened in Nazi Germany, one in particular, a fellow named Carl Schmitt, who was a philosopher and actually a Nazi apologist, said that it was an embodiment of what he called the doctrine of exception. Doctrine of exception. He went on to say what he means is that sovereign is he who decides on the exception. All right, getting out of the legal philosophic realm, what does this mean? Well, it means that in Germany at that time, under Article 48, the executive was given the authority to decide whether or not the rights that were set out in the German Constitution were going to be applied, or whether they could be suspended. And that doctrine of exception meant that if at any time he felt that it was necessary to protect the German people, you suspend all the rest of the rights that are set out in the Constitution. And what happened in Germany, the doctrine was used before the Nazis came to power, but then it was used to justify the elimination by law, because Hitler wasn't just doing this by decree. He also had a very docile parliament, the Reichstag, that started passing racial laws. And there were roughly 400 such laws passed. And they removed Jewish people from civil life. gay people, communists, gypsies, Romani, people of a number of different types and groups that they didn't want to have anything to do with. So I wrote this, in 2012, and I wrote about what I saw as the application of this doctrine of exception by George Bush in the Guantanamo, creating Guantanamo, and in justifying, ultimately losing the right to do what they were doing, that is to hold people incommunicado, without any process in the U.S. prison at our naval station there. So that was part of the argument that was being made. Bush administration saying, look, I have the authority to say it is in national security. The security of the United States requires that we hold these people in this island prison without access to any lawyers or family or anyone else, and without any process. U.S. Supreme Court said, well, Mr. President, and I mentioned this last time also, you don't have that power. That was stripped from the English kings 400 years ago. And in a bit, we'll start talking, focusing on the habeas corpus clause. But we do have a doctrine of exception, if you will, in our Constitution. And that is set out in the authority that the government has to suspend the writ of habeas corpus. Writ of habeas corpus being a right that all people in the country have to go to court and to say to court, my imprisonment by the executive is unlawful. That can be suspended. I mean, it's so fundamental. The Constitution doesn't even say thou shalt have a right to habeas corpus. It's assumed based on the common law that we brought over from England. Can suspend it if there's an invasion or an insurrection. And that is similar to the Insurrection Act of 1798, which Trump has been using. But Bush and now Trump have gone way beyond invasion or insurrection, although Trump is trying to argue, and so far unsuccessfully, that if Venezuelan gang members, come into the country illegally, that's an invasion. That is not what anyone contemplated anywhere in the history of the statutes being passed 200 and some odd years ago. They justified, Bush, Trump, their assertions of power based on national security, based on declaration of a national emergency. And to be sure, Congress has given the presidents for at least 70, 80 years, the authority to declare emergencies and take certain actions, by executive order. But Trump has pushed that so far beyond any boundaries in the same way that Hitler did. Now, not yet in terms of putting gay people and Jewish people and black people or disabled people into prisons or euthanizing them. Not yet. But the principle that they're asserting, this doctrine of exception, says, look, I'm the president. I declare that it is that national security requires this extreme action, kicking these, migrants out without process. And now, send him to El Salvador. Now, today, he's supposedly, actually planning, to send some to Libya. I say that's in the national interest. And there's no transparency. There's no settled law. There's no right to process. He just says, I say so. And you, the courts, can't challenge what I am doing. That's such a parallel to what happened in Germany when you look at the justifications that were given then. We'll use the law to rewrite the law and to ignore and change the law because we say it's in the national interest. And that's the same thing that's happening today. That's the parallel that I see here.
I mean, you'd also mentioned a docile parliament. So,
Yes.
I mean, so what you're saying back then as well, there was, I'm not completely familiar with the structure of government that the Weimar Republic had, but essentially any outer check on the executive didn't seem to exist, similar in the way that Congress is sort of abdicating its role. So is that right? Or is that what you're,
Yeah. Yes. I mean, that's what the people who wrote about what happened in Germany in the 30s, said. There was at the outset a German parliament that could have acted. They didn't. We have a Congress that could act, but hasn't. Rand Paul, libertarian senator from Kentucky, sponsored a bill with respect to the tariffs to rescind the authority that Congress had given to the president decades ago to impose tariffs in certain circumstances. He said, look, Trump is abusing that power. That's not what was intended. Regardless, let's get rid of it. He was joined by Lisa Murkowski from Alaska, Susan Collins from Maine, and 46 Democrats. Vote was 49-49. Not one other Republican senator, joined in that. Congress, on the House of Representatives, has a provision that certain of the emergency powers that it is given to the president can be withdrawn by vote of Congress. And the statute said that if such a motion is put forward, it must be voted on within 18 calendar days. So the Republicans in the House did a wonderful adaptation of George Orwell's doublespeak, newspeak from 1984. And they included in one of the bills that they passed a provision that calendar day is redefined as being, there's one calendar day from whatever day it was in February or March that they passed this until the end of the fiscal year, September 30. So that no Democrat or no Republican could force a vote on the House floor to rescind any of the emergency powers that presidents were given in several different statutes, as I said, over the last 70 or 80 years. That's a pretty docile and compliant Congress that has ceded the power. And you have to ask, why? Is it power for the sake of power? Why are they in Congress at all? Where is their belief that it is a co-equal, if not the first of the three co-equal branches of government? Because Congress is set up in Article 1.
Yeah.
But they're letting it happen.
Yeah, I mean, when I listen to commentary either through podcasts or news, we do hear people talking about other fascist regimes and the lead up to it and how it resulted. But we keep coming back to the parallels with Hitler and Germany. And it's just remarkable that, there's someone was saying recently that the reason why a lot of this stuff can happen now that parallels so much what happened in Germany is the generation that was around for that actually experienced it, that went through it, lived through it, and the years after are dying, have died, are no longer in our society. So we don't have that memory of that experience anymore. And so people can't relate to that history or understand it. And I don't know. I mean, what are your thoughts about our inability to reflect back on these past historical moments that produced such egregious atrocities and disrupted, in that instance, the entire world? And it seems like we're back in, again, a parallel situation.
I don't have an answer for that, Bob, and I wish I did. If I did, you and I would be having this conversation in a forum with 80 or 800 million people instead of the wonderful core that you have put together here in Oregon, and people who listen in from outside of Oregon as well. If it's not personal, I mean, I'll get back to what I was feeling and what I said about, the Seder. I spent my whole career fighting for the rule of law. I've spent my whole career standing up in court and saying to judges, I disagree with you, you're wrong. And I still said, well, I don't feel the fear. I mean, reality is I do. And boy, having, brought that forward in my brain, feel it very strongly. Playing tennis yesterday, and one of the people on the tennis court said something, about what's happening at the Newark airport. So I grew up, near New York City. She grew up near New York City. So, we're talking, well, she says, don't fly into Newark. Why? Because they don't have the air traffic controllers. It's happening.
Yeah.
It's there, but we don't feel it. Unless the plane goes down in our backyard, well, it's happening out there. It's happening to them. It's happening to the other. And, if it happened to your parents, it's different.
Mm-hmm.
I don't know what else to say about that.
This is a bit of a tangent, but I've been now twice to Montgomery, Alabama, and visited Bryan Stevenson's National Memorial and the Mass Incarceration Museum. And it is the history of this country and the atrocities and the harms and the ongoing, white supremacy manifestations of harm created by white supremacy, all in its physical history there. And he's added, now another park. And, when he first did it, because he's a civil rights attorney, works, on mass incarceration issues. I didn't understand it. Like, it took me a second to catch up to where he was getting at as far as the importance of keeping that history front and center so we never forget it. And he talked about his experience in Germany where he said you can't go anywhere in Germany and not be reminded about the Holocaust or what happened in World War II. And, his acknowledgement of if that history is right there in front of us, it prevents us from recycling it or repeating it. And one of the things with this country, which is, I think, so extraordinary, is the way in which we build and destroy, build and destroy, build and destroy. We don't have that connection to history. We wipe it clean. And, it happens every generation or two where we just forget about the experiences of the past. And, it just reminds me of how important it is that, to be able to remind people of that history. And, it was just some thoughts that were, as you were talking, just thinking about that. But,
well, I think that is such an important point to make in the context of the Trump administration's so intentional efforts to rewrite American history.
Mm-hmm.
What is all their talk about? Well, Harvard, Georgetown, law firms. You can't have diversity, equity, and inclusion. And you can't teach about race and racism in this country. They're trying to erase that. I mean, push farther back out of everyone's consciousness the reality of race and racism in this country. It is so pernicious, what they're doing. And it'll make it that much more difficult if they succeed for the next generation to have, even the understanding that this generation of people has. It is just, it's just wrong.
Yeah. And maybe in some subsequent or follow-up podcast or recording, we can dig a little bit deeper into that. But, there's a couple of things that you mentioned, in the previous conversation that we had and in this conversation, that you as an attorney, you spent your whole life, in promoting the rule of law and sustaining the rule of law and defending the rule of law. And that means that you got to go in court and defend actions, defend individuals when the government was trying to prosecute them or detain them, incarcerate, whatever it may be. But inherent in that, and what you're saying is that there is a process, that you engaged in a process in an open forum in which you were allowed to understand the accusations or allegations against the clients that you were representing, and to be able to challenge that in an adverse setting to get to the reality or the truth of what happened. And, this is such a core concept in our legal system. And, we talk about it as due process, but can you talk a little bit more about that? Because we're hearing about the attack on due process right now. I mean, where is due process found in our Constitution? Why is it so important? This is a compound question with we could spend hours on, but why is it so important? And, and we're talking about, does it apply to certain people or does it not apply? I mean, where are we at with it for people who are kind of entering this conversation for the first time?
Sure. So let's start with history and ask, why did the constitutions of many of the colonies, when they were written in the 16 and 1700s, include due process clauses? Well, the answer is because the lack of process in Mother England was fresh in their minds and experiences. England had a legal system. England had judges. But for many crimes, no lawyers were permitted. You couldn't have a lawyer with you. There was a crown prosecutor, but there was no one to stand with the accused against the crown prosecutor. People could be tried in secret. Many people may have heard of the Star Chamber. The Star Chamber was a place where, certain types of crimes could be prosecuted in secret. You didn't have originally a right to confront your accusers. You didn't have a right to notice of the charges against you. And when the drafters of the Constitution were meeting in Philadelphia, they crafted the Bill of Rights, the first 10 amendments to the Constitution, and included, number one, freedom of religion and freedom of speech. 2, right to bear arms. However, and whatever that means, a lot of people disagree with the current interpretation of that. The right not to have, people, quartered, soldiers come and sleep for free in your house. 4th Amendment, you get to the right against unreasonable searches and seizures. King and your bloody, guards, you can't come into my house unless you have gone to a judge and you get a warrant probable cause to believe that there's something criminal, afoot here. And then you get to the Fifth Amendment to the Constitution, and that's the first place that you find, due process. And the due process, the Sixth Amendment has a right to counsel and the right to confront your accusers. The Seventh Amendment has a right to a jury trial. And when we go forward to the Civil War, you find the adoption of the 14th Amendment repeats with respect to the states, because the 14th Amendment is a limit on the power of the states. The first 10 amendments, the Bill of Rights, are a limitation on the federal government's power. So the Fifth and 14th Amendments both have the phrase you have the right to due process before you can be deprived of life, liberty, or property. And due process is then defined in judicial opinions. And what it says is, look, government, if you're going to throw me in prison, or if you're going to execute me with the death penalty, if you're going to take my property away, you have to give me notice of the reason why you're doing that. You have to tell me the legal basis, the statute under which you are going against me. You have to give me the opportunity to listen to what evidence you have in front of a neutral and detached judicial officer, judge, magistrate, whatever you want to call it. And you have to give me the right to say, no, wait a minute, you're wrong. Then you get to the Sixth Amendment, and more specifically, I also have the right to have a mouthpiece, a lawyer with me, and I have a right to see and hear directly those people who are, presenting evidence against me. But the notion of due process is fundamental fairness. Now, government, you can't do anything to me, against me, unless you treat me fairly. And our notions of fairness generally involve those things that I've just mentioned. So that's what due process, is about, and where it comes from.
And, just as a point of clarification, I mean, you read the text of the Fifth Amendment. Who is the Fifth Amendment applicable to within sort of the boundaries of the United States? I mean, this is a conversation that we're, for some reason, having, but there seems to be people are questioning, is it anybody, citizen, person, non-citizen, immigrant? I mean, this is almost a rhetorical question, or a T-ball question for you, but can you provide clarity on that as far as who this protects?
Absolutely. The first two words make that clear. And I don't know that there's any room around this. No person. Mm-hmm. It doesn't say no citizen, no person legally in the country. It just says no person. End of story. I mean, I don't get it. Why and how people are attempting to argue, well, there is no question that there are certain rights that a citizen would have that a non-citizen would not. Like maybe the right to vote. But with respect to due process, Mm-hmm. And the Supreme Court, in the wishy-washy Abrego Garcia opinion that it wrote, facilitate his return, they made clear, they restated what was stated in the Guantanamo litigation in 2008 in the Boumediene case we talked about last time. That doesn't matter. Doesn't even matter if you're an enemy combatant, for God's sake, arrested on a battlefield. If you're in the United States and Guantanamo is part of the United States, you have a right to process, the due process. Now, it may be a different degree of process that you have if you're not being charged with a crime. If the issue is your deportation, you don't get all of the rights that you get if you are charged with a crime, like presentment to a grand jury. Can't be prosecuted in the federal court and in most state courts without a grand jury indictment. You don't get that if there's an immigration proceeding. So administrative proceedings, the process that you are due, that you're entitled to, can be less. But it still includes notice and opportunity to be heard, two basic components.
And, we talked a little bit about that issue with Aaron when she discussed what was going on with immigration. But, you alluded to this at the outset, the historical origins of due process, why we need it. Can you talk a little bit about its connection to democracy and why it's so important for us? I mean, to me, I will just say, sort of leading you into this is all the Bill of Rights that are so critically important to ensuring democracy in this country for different reasons. But due process, the idea to be able to make sure that exists against the awesome power of the state. I mean, why is that so important?
If you believe in democracy, if you believe in rule, of the people, by the people, for the people, to quote President Lincoln, you understand that the check on the power of the executive, the guide rail, the impediment to the executive, be it president or king, asserting absolute power, is a requirement that all of his subjects, that is, we the people, no person, have the right to some process if the king wants to take action against us. I mean, it's a first line of defense, if you will, against autocratic rule. Autocratic rule, the rule by a dictator, where the dictator gets to say, I'm the dictator. I get to make the law. I get to decide if you're guilty. I get to decide if you should go to prison. I get to decide if you should be executed. I get to decide if you should go to Libya, and no one can stand in my way. Well, due process says, stop. You can't do that unless you give the person some process. And then the other rights flesh out and strengthen that. I mean, one of the things that I have said multiple times in lectures over the years is that the Sixth Amendment to our Constitution is one of the most revolutionary parts. The Sixth Amendment saying you have a right to counsel. Now, I said that, in jolly old England, a lot of the crimes, not only didn't you have the right, you couldn't even, bring in a lawyer if you wanted to. Well, our founders recognized that if you're going to have a process, a trial, a hearing in front of a neutral and detached judicial officer, in which the government is being represented by a trained professional in a criminal case called a prosecutor, you, the accused, need to have with you someone who is also trained in the law and experienced to stand by your side against that government agent. That did not exist anywhere in the world at the time the Sixth Amendment was adopted. Now, the reality of the history of our country is it took 163 years from the writing of the Sixth Amendment until, in the case of Gideon versus Wainwright in 1963, the Supreme Court said, if that right to counsel is going to be meaningful, it has to include the right to have the government pay for a lawyer if you can't afford to. Reality in all our courts, state and federal, is that 80-90% of all prosecutions are of people who don't have the money to actually hire an attorney. So if you're going to have a right to counsel under the Equal Protection Clause of the 14th Amendment, as now understood to be part of due process, government has to treat you equally. If you don't have the money to hire someone to stand against the paid prosecutor, they have to pay for it. 163 years it took for our nation to, formally and hopefully finally adopt that principle to recognize that reality. Well, we got there. But the Sixth Amendment, when passed in the late 1700s, was a revolutionary act. Yeah. And boy, we should be proud of that.
Because it's so interesting, like how when you start looking at the different amendments, the Fourth, Fifth, Sixth, Eighth Amendment, how it all protects the individual from the abuses of state power. But without that process, those other amendments can't really truly be sort of realized, right? Because you can't really, unless you have that process, you can't really bring evidence of an illegal search and seizure, right? It becomes very complicated. Or if you don't have that process, there's no need for an appointed attorney or have an attorney. And same with the Eighth Amendment, you can't demonstrate or try to demonstrate without process that this punishment is cruel and unusual. And that's why for me, like that is such a linchpin in protecting people from the awesome power of the state. And I guess, just some final thoughts, because I do want to introduce habeas. I want to have a follow-up conversation just on habeas because it's been so much of your practice and the litigation that you did on behalf of Guantanamo detainees. What is the danger right now with what Trump's doing around due process and the conversation? What do they call it? What's that window? I always forget the idioms. I forget what it's called, some idiom, but how the window is shifted. And now we're actually talking about whether or not due process is applicable and when it's applicable, as opposed to, 5 years ago, it wasn't even a question. Overton window, that's it. So, but yeah, can you just talk a little bit about the dangers of what's happening right now and sort of where we're at? And you've alluded to it all over the place already.
Sure. It's in sum, the Trump administration is asserting the authority to unilaterally decide that a person is unlawfully in the country and remove him without any process at all. That is an anti-democratic position for all the reasons that we have just discussed. If we understand that due process, that a right to due process is the first line of defense, if you will, against an abusive, overreaching executive authority. When you take out that line of defense, you have opened the gate for the despot to do whatever he wants. When the despot says, I'm the federal law. Well, the despot eliminating the process that would otherwise exist to check his assertion of that power, now has free reign.
Yeah.
Goodbye, democracy.
And I think like the key is at least for me, what I keep thinking about is the way in which they're defending this, because due process is applicable to all persons, as you mentioned. And so once you start taking it away for someone or somehow concede that it doesn't apply to someone, you've already gutted the Fifth Amendment and the principles and spirit behind it, and what it says, saying that somehow some people are excluded. There's an exclusion to that. And that's the thing that scares me the most, is the way in which they're defending this power. I want to move in the last 5 minutes that we have, 10 minutes that we have here, to introduce this concept of habeas, because we talk about due process as the front end, as ensuring that there's process before someone's detained. But the backstop, and you talked about the importance of habeas earlier. The backstop in this country is habeas. It says if you're illegally detained, you still have the ability to go in front of a court. Can you explain this concept of habeas generally? I mean, the history, a little bit about the history. I know you could give a whole lecture on this, and you have, but
I have.
Yeah.
All right. So in a nutshell, every student who I've had the pleasure of teaching or has had the misfortune of listening to me leaves the classroom having heard about what happened at Runnymede in the year 1215. And every intern at the Oregon Justice Resource Center, Oregon Innocence Project, and Federal Defender Office has heard the same thing. Why? Because the barons, and it wasn't the people and it wasn't any poor people, but it was, the landed gentry, decided in 1215 that King John had run him up, and they took him out into this field at Runnymede and had him sign Magna Carta, the Great Charter. And Magna Carta is the document from which ultimately the writ of habeas corpus was derived. The barons said in 1215, King, sorry, you no longer get to do whatever you want with us, and we're entitled to process. Over the next couple of hundred years, there were several statutes that were passed, and power ebbed and flowed until you get to the 1600s. There was something that was called the Petition of Right in England. Petition of Right, equivalent to the writ of habeas corpus. By then, a judiciary had been established in England. And under the Petition of Right, if you were imprisoned by the king, you had the right to petition, put a paper, write on a piece of paper, make it into a paper airplane, throw it out of the Tower of London, hoping a judge would, pick it up and have a hearing. The judge had the power to order you brought forward. Habeas corpus, literally meaning bring the body forward. King Charles I, I think it was, didn't like it. He suspended Parliament, which had created this Petition of Right, led to recreating, in 1641, and then there was a civil war in England, and eventually 1679, things settled down, and you have a writ of habeas corpus in a form quite similar to what we know today in this country from England, giving the judiciary in England the authority to direct the sheriff to bring a body out of the Tower of London, where the king had put it, into court where that person could say, I'm being held unlawfully. Writs of habeas corpus were incorporated, or the absence of ability to get rid of the writ or suspend it was incorporated in most of the colonies' constitutions, same as writs of due process clauses. So in the writing of our Constitution, it was assumed that the common law of England, which was the foundation for our law, included the right of a person in prison to say to a judge, issue this writ, direct the sheriff, the marshal, whomever, to bring me out of the jail into your courtroom and order the jailer, whoever that would be, holding me, Federal Bureau of Prisons, Attorney General, President himself, to show cause why my incarceration is lawful. And I said before, it can only be suspended in our Constitution if there is an invasion, Japan, invading Hawaii, Germany, or an insurrection, the Civil War, the South. You can suspend the writ. But as soon as the invasion or insurrection is over, the writ comes back into play. So it has been suspended a couple of times in our history for the reasons that the founders intended. That is, the country was invaded and or in the Civil War instance, there was an insurrection. So the writ of habeas corpus, and I think I mentioned this last time, when Justice Kennedy wrote the majority decision in the Guantanamo cases, he recited that history. He recited that history so that all lawyers and any non-lawyer, any U.S. person reading the decision would understand he wasn't making anything up. That the authority that he was restating that the judiciary had to inquire into the legality of the imprisonment of the men in Guantanamo was hundreds and hundreds of years old and fundamental to the functioning of a country that called itself a democracy, a country in which the power of the central government was limited. That's what it's about. So habeas corpus is an analog of due process. It is a vehicle by which a person who has been held without process can force a process upon the executive who has seized him and imprisoned him, and authorizes the judicial branch to conduct that process. That's what habeas is about. And it sits, as I said, it's an analog. Maybe that's not the right word. It's an adjunct to due process. It's the mechanism to force process on a recalcitrant and overreaching executive branch.
I mean, this is the only word that kind of comes to me, but there's elegance in both the Fifth Amendment and habeas. The idea that you get process at the outset, but to have the ability to really understand, still there needs to be a mechanism, even though it's stated that there's this process, and still people can be prosecuted or, criminally convicted, but there's still this failsafe that exists to ensure that there's not, illegal detention that's occurring, that there's a mechanism for people to be able to come to the court and, like you said, force process. I mean, to me is, it's just very elegant, very powerful. And I think it speaks profoundly to the fears and the concerns, I think rightfully so, of the abuse of power by states, by an executive or a king. I mean, just because in history it happens.
Absolutely, Bobbin. It is. And the way you just phrased that, I think is very important, because I said that it's a way to force process if the government has not given you process. You added another very important piece to that, because the government can give you process. The government can go through a trial, but the government can abuse its power in the process that has been created. So it can violate the rule of law. Any number of times in my cases, I have said that the conduct that you are charging my client with is not criminal. I mean, you, the prosecutor, reading the statute, you're just wrong. It doesn't say you can't do X, or the prosecutor will violate a Fourth Amendment right against unreasonable search and seizure, or a due process right to have a fair hearing. The judge falls asleep. The judge is biased. The jury is bought off by the prosecutor. All those things happen. So even if the government creates a process, individuals can pervert it and not comply with the law. Even prosecutors and police do that. Or it can write a law that violates a constitutional right. You can write a law that says, you may be a black man, but you're not allowed to have any black people on your jury. We're not going to call any black people in. Well, that violates your right to equal protection. And so if you go through a normal judicial process and your state won't vindicate your rights, you get to go to the federal court and say in habeas corpus that you have had process, but it was not a constitutional process. And under the writ of habeas corpus, the federal court can order you either released or retried. And that happens, hate to say it, all the time.
Yeah. So it is interesting to keep them kind of separate because, as you just really eloquently explained, what happens in habeas and sort of criminal cases and how they play out and what your office did when you were the federal defender of Oregon, but then also in the instances in which you're denied process and just incarcerated or detained using habeas as the backstop. So, there are two different paths there, but ultimately there is that backstop that exists. And that's what's so profound, at least about the mechanism or the right of habeas to be able to access habeas. I guess just in these final moments, and we'll come back because I really want to explore with you in a future conversation, some of the Supreme Court cases around habeas, what happened in Guantanamo, and the things that are setting up now. But I think the two things that I like to hear your thoughts on is the dangers of what's happening again, sort of right now, the importance of habeas. And then, very quickly, like how this administration is trying to evade the ability for people to be able to access habeas. Can you just touch on those points? And we'll follow up. We'll have a more deeper conversation about all of this.
Sending people out of the country to a prison in a foreign land is a direct violation of the right to process, which the Supreme Court has said. Abrego Garcia had that right. They're just ignoring the process. And now today, the news says they're going to send people to Libya. That's even farther from any country that any of these people would be in. They don't speak much Spanish in Libya, I imagine. So I don't know what the hell they're thinking, except that, it's farther away. It's easier to hold people incommunicado. In the habeas litigation in the spring of 2004, while I was representing Brandon Mayfield, and I had to tell him this, The Deputy Solicitor General was asked in a Supreme Court argument, why'd you put these men in Guantanamo? And he admitted, because we could hold them incommunicado, because we didn't want them to have access to lawyers and be able to challenge what we were doing. Now, thank God there were pro bono lawyers, nonprofits and people in law firms who were giving their time, who were doing their representation anyway, even though they had never met their clients. Sometimes they didn't even know the names of the clients. And sending people to El Salvador and now potentially to Libya, it's even worse, because Guantanamo was part of the U.S. Well, in these other countries, there is no jurisdiction. What's the remedy that a person would have? Well, the goodwill of the president to comply with a Supreme Court order, which so far there doesn't seem to be any. Send the U.S. Army to El Salvador or Libya to bring these guys back. It's insane. The whole thing is. I mean, it is such to me, it's a step beyond what was done during the Bush administration, and a direct thumbing the nose of, upthrust finger at the notion of democracy, the notion of the rule of law, and with respect to the immigration and order of the U.S. Supreme Court. That's scary.
Yeah, it is very scary, because essentially what the Trump administration is doing is trying to outmaneuver or outspeed the courts, essentially violate someone's due process rights or other constitutional rights, remove them from this country, and then basically say, well, courts, if someone within 24 hours, so by the time an attorney can file a habeas petition, the government, the Trump administration is essentially saying, you don't have jurisdiction. There's no way then to vindicate the violations that have occurred. And this is very scary, because it's such a disturbing way in which, they're trying to evade judicial scrutiny and like you said, undermining the rule of law. Yeah, I mean, I think there have been some litigation where attorneys have been able to file habeas petitions pretty quickly, or preliminary injunctions or TROs, to try to stop people from getting out of the state even, or out of the country. And then there's a shell game of trying to moving detainees from federal institution to federal institution. So you don't even know which court to file the habeas petition in. So, yeah.
It is a very dangerous time, and the remedy, if you don't have jurisdiction to physically get the person back, it seems to me, is to punish those government officials who are sending them there. But to punish government officials for sending people to the foreign countries, you need to have a clear and precise judicial order, such as that issued by Judge Howell in the Perkins Coie case, that would set up the contempt proceeding. And Judge Boasberg and Judge Innes, in a couple of the immigration cases, wanted to hold contempt investigations. And at least so far, the higher courts have put those on hold. And I say we just have to hope that those proceedings are permitted to go forward, because if you believe in the theories of deterrence that underline our criminal law, perhaps the government officials would be deterred if they find that they can be held in contempt and imprisoned for sending people to El Salvador and Libya, and they'd stop doing it, and or actually make good faith efforts to get the people back. But we're not there yet.
Well, we'll have, I think, additional conversations about Habeas and the litigation that you did, and I think the parallels or the things from those litigation, why it was so important and what it set up. But just to wrap up today's conversation, I figured it'd be nice to close with the confessional again. Would you mind doing another reading of that?
First, they came for the communists, and I did not speak out because I was not a communist. Then they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak out for me.
Yeah, I think thanks for walking us through all this history. It's always very insightful and helpful, and it helps contextualize the importance of all of this.
Well, I appreciate your thanks, Bobbin, and I sure appreciate the fact that you're doing this and supporting this work and so important.
Powerful. I mean, it's an awesome reminder of the importance of standing up and making sure we understand the interconnectedness of all of us and protecting, everyone in our community. Well, thanks for listening. This is another episode of Trailblazing Justice. We'll be back with Steve in the upcoming weeks for Waxing Confidential. And then thanks to Todd Davila as our producer for Trailblazing Justice. We'll see you next week.